Imagine this for a moment. You are sitting at your kitchen table. The morning coffee is still warm. You open a thick envelope from U.S. Citizenship and Immigration Services. Your hands start to shake. The letter says your green card application has been denied. The reason listed: public charge concerns, insufficient financial resources. You read it again and again. You don't understand. You have a job, you have savings, you followed every rule, you filed every form on time. But buried in that denial letter is one small detail. The officer reviewed 12 months of your bank statements, and they saw something you never thought twice about: money you sent to your elderly mother in your home country, money you sent to help your sister pay for her son's school, money you sent because that is what family does. And just like that, years of waiting, thousands of dollars in legal fees, and your entire American dream gone. If this story makes your stomach turn, please stay with me. Because what I am about to share could be the most important 15 minutes you spend this year. I am June, a Senior Policy Analyst and retirement finance expert here at Retirement Tax and Law Pro. For years, I have helped retirees and their families navigate the most confusing rules in immigration, Social Security, and tax law. And today, I am going to walk you through the exact rule that is quietly destroying green card cases in 2026. I will explain what the law actually says. I will tell you the steps you must take to protect yourself. And please stay until the very end, because there is one hidden mistake almost every senior makes when sending money abroad. It is not what you think. And it can cost you not just your green card, but your bank account and your freedom. Let me tell you about Robert. Robert is 67 years old. He came to the United States 20 years ago from the Philippines. He worked hard, he paid his taxes. He raised 3 beautiful children, all of them American citizens now. Last year, Robert finally filed his adjustment of status to become a lawful permanent resident. His daughter, who is a U.S. citizen and a registered nurse, agreed to sponsor him on Form A-864. On paper, everything looked perfect. His daughter earned well above the poverty line. Robert had no criminal record. He had a stable home. He had savings. But Robert did one thing. Every single month, like clockwork, he wired about $800 to his 89-year-old mother back home. She needed it for her diabetes medication. Sometimes when his nephew got sick, Robert sent extra. Maybe $2,000, maybe $3,000. He never thought about it. It was his money. It was for family. Then USCIS sent a request for evidence. They asked for 12 months of bank statements from both Robert and his daughter. When the officer added up the foreign transfers, the picture changed completely. Robert's daughter, the sponsor, had been quietly transferring money too to help her grandmother. Once those outflows were subtracted, her available household income dropped below 125% of the federal poverty guidelines. The case was denied, not because Robert did anything illegal, not because the money was dirty, but because in the eyes of the officer, the household no longer looked financially stable enough to support him. Robert is now waiting 18 months for a chance to refile, and he is one of thousands. Now let me explain the rule in plain English, the way I wish someone had explained it to Robert before he filed. The law is called public charge inadmissibility. It comes from Section 212A(4) of the Immigration and Nationality Act. In simple words, it means this: if you are applying for a green card, the government must believe that you are not likely, at any point in the future, to need government financial help. To make that decision, USCIS uses something called the totality of the circumstances test. They look at your age, your health, your education, your family situation, and most importantly, your financial resources. They look at what comes in, and they look at what goes out. Here is what changed in 2026. On November 19th of 2025, the Department of Homeland Security published a new proposed rule in the Federal Register. This rule gives officers much wider discretion to weigh your financial conduct. That includes money you send abroad. Then on May 22nd of 2026, USCIS officially announced that granting a green card is now, quote, a matter of administrative grace. That phrase matters. It means even if you meet every single requirement on paper, an officer can still say no based on judgment. Now, your sponsor, the person who signs Form I-864, must prove household income at 125% of the federal poverty guidelines. If their bank statements show large, regular transfers leaving the country, USCIS can decide that the real usable income is lower than the gross salary suggests. And that alone can sink the case. There is more. If you transport more than $10,000 in cash in or out of the United States, you must file FinCEN Form 105. If you receive more than $100,000 in gifts from a foreign relative in a single year, you must file IRS Form 3520. If you deposit or withdraw more than $10,000 in cash at your bank, the bank automatically files a currency transaction report. And if you try to be clever and split that into smaller amounts, that is called structuring. It is a federal felony under Title 31, Section 5324 of the U.S. Code. Up to 5 years in prison. I want you to hear that clearly. Up to 5 years in prison for trying to avoid a paperwork requirement. I know this sounds overwhelming, but here is the good news. There is a clear path to protect yourself. So let me give you 3 exact steps to follow, starting today. Step 1. Before you file any green card paperwork, audit your bank statements for the last 12 to 24 months. Sit down with a notebook. Write down every single international transfer, every wire, every Western Union receipt, every Zelle payment to someone abroad. If you see a pattern of large outflows, talk to an immigration attorney before you file. You may need to add a household member using Form I-864A or bring in a joint sponsor with a second Form I-864. This single step could save your case. Step 2. Always file the right form for the right transaction. If you are flying internationally with more than $10,000 in cash, pre-file FinCEN Form 105 online at fincen105.cbp.dhs.gov before you ever get to the airport. If you receive a foreign gift over $100,000 in a year, file IRS Form 3520 with your tax return. And when you use a remittance service like Western Union or Wise, save every single CFPB mandated disclosure receipt. Keep them in a folder. Those receipts are your proof that the money was lawful, traceable, and properly documented. Step 3. Never, ever try to structure your transactions. Do not split a $15,000 transfer into 2 $7,500 transfers to stay under the reporting limit. The bank's computers are designed to catch this. Your account will be flagged with a suspicious activity report called a SAR. You will not be notified, but the FBI and Homeland Security will see it, and it will follow you into every immigration application for the rest of your life, including your future citizenship case. Now here is the hidden mistake I promised you, the one almost every senior makes. It is this. They believe that sending money to family abroad is a private matter between them and their bank. It is not. Under the May 2026 USCIS policy, your financial behavior is now a permanent part of your immigration record. Even one small civil violation, even an unfiled Form 3520 from 3 years ago, can be cited as a negative discretionary factor when you apply for naturalization later. The mistake is not the sending of money. The mistake is sending it without a paper trail, without the right forms, and without thinking about how it looks to a federal officer 5 years from now. Please, do not learn this lesson the way Robert did. If you, your spouse, your adult child, or anyone in your family has an active green card case or is even thinking about filing one, take action this week. Pull your bank statements, check your transfer history, talk to a qualified immigration attorney and a tax professional. The cost of an hour of their time is nothing compared to losing your green card or facing federal charges. And please, do not rely only on YouTube notifications to keep you informed. Channels disappear, algorithms change, rules update every few months. Bookmark the official sources I mentioned today: USCIS.gov, IRS.gov, consumerfinance.gov, CBP.gov. Check them yourself. Trust, but verify. If this video helped you, give it a thumbs up. Share it with someone in your family who sends money home. They need to hear this before it is too late. Subscribe to Retirement Tax and Law Pro and turn on the bell so you do not miss the next video, where I am going to break down a brand new Social Security rule that is quietly reducing payments for thousands of seniors this year. This is June from Retirement Tax and Law Pro. Stay informed, stay protected, and I will see you in the next one.